Mr. Sullinger, pleaded not guilty is entered in your behalf on these charges. Attorney Arraignment is entered in your behalf. Counsel, is there a question?
Thank you, Your Honor. Yes, there is. Sarah Ellis for the Commonwealth. The Commonwealth is seeking $5,000 cash bail in this case.
Very good.
As well as,
Are there any questions there? You're ready, that's right. Jamie, do you have a question?
there is a request for conditions as well under Section 58 in conjunction with the cash bail.
Correct. All right, I hear you when you're requesting.
Thank you. Your Honor, the Commonwealth is asking not only for the $5,000 cash bail, but also for the following conditions: that the defendant be ordered by the court to stay away and have no contact with the victim, to not abuse the victim, to undergo an evaluation by probation for anger issues in the form of either a mental health evaluation or however probation deems warranted. And we had a preliminary conversation about that, as well as to provide notice to probation 48 hours in advance of any travel outside of the Commonwealth of Massachusetts. I understand from conversations with defense counsel that may raise some concerns, that there may be the ability to reschedule to probation, but at this time that is the Commonwealth's request. The Commonwealth is basing this request for cash and conditions on the facts of this case.
Right, just on the question of those conditions, I appreciate the stay away, and I appreciate the no contact. I do believe that 276 Section 58 does allow me to restrict his associations. It does allow me to have him stay away from certain addresses. I don't know if 276-58 by itself allows me to require him to do affirmative things. And if you can point that out to me, I'd be glad to even go down that path. But otherwise, I don't think 276, unless it's agreed upon, and that would be a different statutory section. I don't believe 276-58 allows me to tell him about potential treatment and talk about it.
I don't believe that these conditions are agreed upon, although we have discussed that. So
That's why I turn to you. If you want those provisions, I just tell you, you might want to think about other statutory requests. Because I don't think 276 Section 58 allows me to do that.
we would argue, Your Honor, that under the 2010 crime bill, from a legal analysis perspective, that condition such as the notice about the defendant's travel outside the Commonwealth is within the ambit of Section 58,
Sure, stay away, no contact, tell us this is legal. If they tell him to affirmatively enter into consultation with a mental health advisor to see if he's got anger issues or other type of issues, I think it's beyond 276 Section 58 by itself. Though there are statutory provisions that do allow you to do those requests.
Well, we would ask respectfully, Your Honor, that if Your Honor is disinclined to so order that under Section 58, to consider it under Section 58.
It's not a personal disinclination, I want to be clear about that. It's whether the statute allows it.
Thank you, Your Honor. In terms of the basis for our request,
My question is, before we go down what type of hearing do we have? And are we going to continue to proceed only under Section 276, Section 58, if you know that the court can't grant the provisions that you're asking?
well, respectfully, Your Honor, the Commonwealth disagrees with the court's analysis of Section 58 as it pertains to mental health evaluation or the anger evaluation.
I'll be glad to hear from you where that provision provides for that. It's part of your argument.
Yes, Your Honor. And our argument is just based on the legislative history of that statute.
I'm just going to take a look at that. That's everyone. We'll just take a brief recess while you can talk.
Thank you.
Thanks.
Thank you, Your Honor. Thank you for the recess. I
Sure.
have had the opportunity to consult with the text of Section 58.
Yeah.
And it's the Commonwealth's position that asking for the mental health or anger evaluation is is a prerequisite to any request for restriction on conduct. So for that reason, the Commonwealth argues that it is within the ambit of Section 58. To go ahead and ask that the defendant be restricted in this manner without first having had the opportunity to be evaluated to see which program would be most appropriate, which course of treatment. The Commonwealth argues would be the proper course. So for that reason, we argue that it is within the court's discretion under Section 58.
And I'm going to be clear to you that my reading of the statute would make it very limited to what we can do in pre-stage process, but we're still in the presumption of that. Certainly, the legislature does, if a justice or a clerk of the district court determines to be necessary, the defendant may be able to provide by specific restrictions on his personal associations or conduct. Restrictions on his associations, restrictions on his conduct, including but not limited to contact with victims and the potential witnesses who may testify concerning the offense and condition. So the nature of the example is just as you suggest, the state of the conduct. And the court has no problem with that. But you're suggesting that you need more information to determine whether that stay away or that no contact is necessary with a precondition of asking for it. I'll certainly give you that time. But I can order that stay away, and I can order that no contact without any further evaluation. But I do not think I can require him to do affirmative restriction. I don't think they have the authority to command his behavior in any particular fashion. So it's with that sense of understanding on my behalf, I just want to make sure that you still want to proceed in this section rather than proceed in the section that might allow you to have those things done.
Well, Your Honor, as a preliminary matter, let me state that in terms of the no contact and the stay away order of the Commonwealth,
And that's not a problem. That's not, when I say it's not a problem, that's not an inappropriate request. I have to hear everything to make a decision about that. But I can just tell you without knowing anything, asking someone to engage in treatment and discuss matters with somebody permanently, I don't think I can do as a condition of straight bail in Section 58. In fact, I'm telling you, I know I can't.
and Your Honor, just that the evaluation would be a prerequisite to asking for a stay away or no contact, but rather asking for enrollment in any kind of program, which I believe is what Your Honor is communicating as well, that you feel that the court is under the understanding to not be asked for under Section 58.
It's clear to me it cannot be asked for in the Section. But there are provisions that do allow you to ask for it if it's necessary. Now I'm trying to give you the opportunity, if you thought that was essential, to do that.
Well, Your Honor, it appears to the Commonwealth that the only section under which that the court would be inclined to defer allow the Commonwealth to be heard by such a petition would be Section 58A, because it's not agreed to under Section 87.
Sure. Let me just see counsel for 1 second.
The facts in this case, with which the court is familiar, are that the victim in this matter, Stan Smith, who is in court today, is present and does, my understanding is, wish to be heard by the court, got into a verbal argument with the defendant, Sullinger, on the 31st of August at approximately 11 o'clock in the morning. The basis of the argument was related to a perceived infidelity on the part of the defendant. The victim in this case began to pack her belongings to leave the residence. The defendant, in response, pushed her onto their bed, climbed on top of her. She tried to get up. The defendant pinned her down. He threw her off the bed and onto the floor. The allegations are that the defendant then pinned her down again, and Ms. Smith was able to grab a telephone and inform the defendant that she was going to telephone police. In response, the defendant grabbed the telephone. He walked away. The defendant then, once the parties were both in the living room, so they moved from the bedroom to the living room, the defendant, it is alleged, pushed the victim again in the living room, and then the defendant left the residence and drove to the airport where he flew to Ohio. And it is our understanding that the trip to Ohio was a pre-scheduled trip arranged